Good evening. Namaskar. I am Advocate Nawaz from Calicut. This is my third video on the new criminal laws. Before we proceed any further, let us understand that this statute has been passed in our new parliament by our own government. Till then, till 1st July 2024, we have been following the Indian Penal Code 1860 drafted by Macaulay. So, for 200 years when British ruled us, they imposed certain laws and they had drafted it according to their convenience to suit the Indian scenario at that point of time. Now things have undergone changes. We are self-sufficient. We are one of the strongest countries in the world. Now we have our own language, our own way of doing things. So the Bharatiya Nyaya Sanhitha 2023, Bharatiya Nyaya Sanhitha, the very name indicates what do we stress into. Bharatiya Nyaya Sanhitha, Indian Nyaya. So we stand for justice. Whereas the former name was Indian Penal Code 1860. Indian Penal Code. It was for, stress was only punishment. Now, a few definitions which we must see. If we are thorough with the definitions, basic concepts of this law, it will be easy for us to understand the sections in detail. What are the ingredients in each section of an offence and whether it will be operative or not. All such things can be understood easily once we are thorough with the definitions. So let's go to a definition called court. Court is defined under section 2 subclause 5 in the Bharatiya Nyaya Samhita 2023. Here court means a judge who is empowered by law to act judicially alone, or a body of judges which is empowered by law to act judicially as a body, when such judge or body of judges is acting judicially. So let us see the corresponding definition that is given in section 20 of the Indian Penal Code. Section 20 of the Indian Penal Code had said like this. Instead of court, it was court of justice. British had called it court of justice. The words court of justice denote a judge who is empowered by law to act judicially alone, or a body of judge which is empowered by law to act judicially as a body, when such judge or body of judges is acting judicially. If you have a close look at the difference, you will see that British had specially said court of justice. A man, if he thinks with his common sense and feels that there could have been many other courts also, some courts of injustice. So why did they say court of justice? Whereas we the Indians thought it is a court. That implies that every court we have trust, we have faith in court, and we are sure that the court will deliver only justice. And that is why the definition has come into court. Now, what is a court? Means a judge who is empowered by law to act judicially alone. So, a judge, when he is acting judicially alone, he is known as a court, or it is known as a court. Now, suppose there is a body of judges, a group of judges, say in the High Court, division bench, more than one. When they are acting judicially, then also it is called a court. So, what is most important is acting judicially. Only when a judge or a group of judges or a body of judges are acting judicially, that means they are involved in judicial proceedings, then only it will be known as court. In our neighborhood, there is a marriage an advocate's marriage or a fellow judge's marriage, then one high court judge comes there, we cannot say the high court is going. Suppose 3 or 4 judges are sitting together and having food in the marriage function. We cannot say the high court is sitting or the court is sitting, because that point of time they are not acting judicially. Only when they act judicially we call it a court. Now, another important definition is document. Section 2 clause 8 deals with the document. Document means any matter expressed or described upon any substance by means of letters, figures or marks, or more than one of those means, and includes electronic and digital record intended to be used or which may be used as evidence of that matter. There is a significant change from the Indian Penal Code as it was defined under section 29. Now, it is again when you see at the section 2T of the Information Technology Act 2000, an electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. What is important in this new statute is any information contained in an electronic form is also a document. It will be admitted as primary evidence. See, earlier it was any matter expressed, described upon any substance. It is not necessary that you should write in a piece of paper. When you think of a document, what picture comes to your mind? A big set of papers, a stamp paper or notarized paper or attested paper or having court stamps and all those things. No. It can be on any substance. Any matter expressed or described upon any substance. Can be on a piece of paper, on a leaf, on a leather, on a wooden thing or anything. Then letters, figures or marks, anything it can be. And more than one of those means. Then that includes electronic and digital record intended to be used or which may be used as evidence in that matter. That means any information contained in electronic form, whether it is in a smartphone, whether it is in a what you call a pen drive or in a CD or anything, and similarly some messages received in our phone, messages sent from our phone, any such electronic information, any such information contained in electronic gadgets will be counted as document. So that is a very, very important thing, because Bharatiya Nyaya Samhita 2023 gives importance to technology. British people, when they drafted this IPC in 1860, they had not even dreamt, they never had in their dreams that one day India would become such a rich country, technologically developed country, having significant changes in the information technology, anything they had not foreseen. But today we are living in this era in the world of technology, hence we have to resort to technology also. That is why the electronic information is also treated as a document. Now, one by one we will see in the next videos. One thing I will tell you, as far as Bharatiya Nyaya Samhita is concerned, when a case comes, we will see what is the section and what are the ingredients of that section, whether it constitutes an offence or not. It is not possible to study all the sections by heart, or to, it is not at all necessary to explain on various sections. Only when there are some significant changes from the earlier statute, we require to do some videos or to aid the learning community or the legal fraternity to have more information on that. Rest that Bharatiya Sakshati Niyamam 2023 and Bharatiya Nagarik Suraksha Sanhitha 2023 that we will discuss later on in the coming videos. Hope you will enjoy listening to this video. Thank you. Namaskar.